The moment an officer asks to hold your ID, you are stepping into a legal minefield. Most people hand it right over, no questions asked. And that's exactly what law enforcement is counting on. Because the second that plastic card leaves your hand, the officer gains total physical control over your most powerful piece of personal property. And what happens next, in many states, in many situations, is completely outside your control. But here's what they don't teach you in driver's ed. There is a critical legal difference between showing your identification and physically surrendering it, a difference rooted in the Fourth Amendment itself, a difference that could determine whether your encounter ends at a routine traffic stop or becomes something far more serious. Stay with me, because in the next few minutes, you're going to learn the exact statutes, the key Supreme Court rulings, and the specific word-for-word phrases that protect you without ever breaking the law. When a police officer leans into your window and says, "License, registration, and proof of insurance, please," most people don't hear a request, they hear a command. And that's not an accident. Law enforcement is trained in what psychologists call framing. The way a question is posed shapes how the listener perceives their options. "Can I see your ID?" sounds optional, but delivered by someone in uniform with a badge at the side of the road with a spotlight in your mirror, it doesn't feel optional. The courts have acknowledged this dynamic. In Florida versus Bostick, decided in 1991, the Supreme Court held that a person is only seized for Fourth Amendment purposes if a reasonable person would not feel free to decline the officer's request and walk away. But during a traffic stop, you are already seized. You are not free to leave. The entire interaction exists in a legal gray zone where your rights are real, but the pressure to waive them is enormous. Here is the line that changes everything. There is a difference between your duty to provide identifying information and the physical surrender of your property to law enforcement. When you're the driver of a vehicle, every state in the country requires you to present a valid driver's license. In California, it's Vehicle Code Section 12951. In Texas, it's Transportation Code Section 521.025. In Florida, it's Statute 322.15. These laws are real, and they are enforceable. But here's what those statutes actually say, and what they don't say. They require you to produce your license, to make it available, to show it. Not one of these laws explicitly says you must physically place your document in the officer's hand. That distinction, seeing versus seizing, is where your constitutional leverage lives. The vast majority of drivers make one critical mistake. They initiate voluntary compliance before understanding the legal landscape of their stop. The moment you roll down your window fully and hand your license through without any acknowledgement of the exchange, you have implicitly consented to a level of access that the law may not actually require. And consent, once given, is extremely difficult to take back mid-encounter. This is not about being uncooperative. This is about understanding exactly what cooperation is legally required, and keeping everything else as your choice, not their right. Let's talk case law, because this isn't speculation, it's established constitutional doctrine. In Hiibel versus 6th Judicial District Court of Nevada, decided in 2004, the Supreme Court held that states may require a person who is lawfully detained to state their name. Note what the court said, state their name. The ruling did not mandate the physical transfer of a government-issued document. The Nevada Supreme Court, in that same case, interpreted identify under state law to mean merely stating one's name. That's the floor of identification law in America. A name. Everything beyond that is state-specific, and even then, the distinction between providing information and handing over physical property remains legally significant. Here is where the stakes get very real and very modern. When a police officer physically takes your driver's license back to their patrol car, they are doing far more than checking that the card isn't expired. Modern law enforcement databases, accessible through systems like the FBI's National Crime Information Center, or NCIC, return results in seconds. Officers can run your name for warrants, prior arrests, restraining orders, immigration flags, and more. Additionally, many jurisdictions have deployed mobile ID scanners that read the magnetic stripe or 2D barcode on the back of your license. The ACLU has documented how this barcode data can include far more than your name and birthday, and that many states have not extended barcode privacy protections to law enforcement scanning in the field. And then there's facial recognition. Multiple states are now grappling with legislation around police use of biometric facial recognition. As of 2025, states including Illinois, Texas, and Washington have passed laws regulating biometric data collection. Illinois' Biometric Information Privacy Act, known as BIPA, is among the strongest in the nation, establishing that biometric identifiers cannot be collected without informed written consent. The key point is this: when you hand your ID to a police officer and look directly at them, you have potentially handed over far more than your driving record. In jurisdictions without strict facial recognition guardrails, that visual data can be cross-referenced with growing law enforcement databases. Your physical ID is the key that unlocks far more information than the card itself contains. Before we get to the scripts, let's talk about what not to do. The most dangerous move you can make during a traffic stop is to argue constitutional theory with an officer at the roadside. That is not the time, and it is not the place. Your rights are vindicated in a courtroom, not on the shoulder of a highway. Officers have wide discretion in the moment, and escalating can create legal problems that wouldn't have existed otherwise. What we're teaching here is de-escalation with dignity, not confrontation. Here are specific phrases that allow you to remain compliant with identification laws while clearly communicating your position. When the officer approaches, roll your window down enough to communicate clearly. Then say, "Officer, I'm happy to cooperate fully. Here is my license, registration, and insurance. I'm going to hold it up clearly so you can see everything. I'd prefer to keep my documents in my possession, but everything is right here for you to review." That's script 1, the polite display. If the officer insists on physical possession, use script 2. "I understand you need to verify my information. Am I being detained? I want to cooperate, and I'm not refusing to identify myself. I am simply asking whether I'm legally required to physically hand over the card or whether I can display it for your review. I'd like to comply fully with the law. Can you clarify what's specifically required here?" And if they claim counterfeit suspicion, use script 3. "I understand. If there's a concern about authenticity, I want to address that. I'd be glad to hold the card in good lighting so you can inspect it closely. If you believe a crime is being committed, I understand that changes the legal landscape of the stop. But I'd like to be clear, I'm not consenting to a search or to the physical seizure of my property beyond what the law requires." Now, about the counterfeit pretext specifically, this is critical. If an officer claims they need to physically handle your ID because they suspect it's counterfeit, they are asserting that a crime may be in progress. Under Terry versus Ohio, that assertion of reasonable suspicion changes the legal calculus of the stop. That doesn't mean you're required to hand anything over without question, but it does mean that you should understand that an officer who articulates specific reasonable suspicion has more legal authority in that moment than an officer who is simply conducting a routine stop. Know the difference. And if counterfeit suspicion is claimed, document everything. In all 50 states, you have the right to record police officers performing their duties in public. The First Amendment protects this right, and numerous federal circuit courts have upheld it explicitly. In Glick versus Counterfeit, the First Circuit held that filming police is constitutionally protected. Turn on your phone, use a dash cam, use a cloud syncing tool so that footage is preserved even if your device is taken. Say clearly and calmly, "I am recording this encounter for my safety and yours." Then say nothing else unless asked a direct question that requires a legally mandated response. Let's pull back the curtain on what happens when your ID goes into a police vehicle. Modern patrol cars are increasingly equipped with mobile data terminals, computers connected to state and federal databases. Some departments also use handheld or vehicle-mounted barcode and magnetic stripe readers. When your license is swiped or scanned, information is extracted from the machine-readable zone on the back of your license. This can include your full legal name, date of birth, address, license number, and in some states, additional encoded data. This information is then run against databases including the NCIC, which contains records on wanted persons, stolen vehicles, missing persons, and more. A visual inspection by an officer who looks at your license in your hand returns none of this data. Only the physical transfer enables the full spectrum query. Here's what most people don't understand about the legal distinction. A visual check of your ID doesn't require a warrant because it's analogous to reading information that's publicly visible. But the moment a scan accesses database records, records that you have not consented to retrieve, you enter a different legal and ethical territory. The Supreme Court in Carpenter versus United States, decided in 2018, established an important principle. The collection of detailed, comprehensive data about a person's movements and activities can constitute a Fourth Amendment search, even when individual data points might be publicly observable. While Carpenter dealt with cell site location records, the underlying principle that aggregation of data creates a privacy interest greater than any individual piece is being argued in courtrooms across the country in the context of police database queries. Your ID is not a neutral document. It is a data access point. If an officer threatens arrest over your refusal to physically hand over your license, here is your structured response. Step 1. Stay calm. Do not raise your voice. Do not use profanity. Do not make sudden movements. Place your hands where they're visible and keep them there. Step 2. Clearly invoke your right to remain silent beyond legally required. Say, I am invoking my right to remain silent under the Fifth Amendment beyond providing legally required identification information. Step 3. If the officer asserts they will arrest you, do not physically resist. Compliance in the moment does not mean waiver of your rights in court. Say, I am not resisting. I am complying under protest. I do not consent to this. Step 4. Request a supervisor. You have the right to request a supervisor. Say, I would like to speak with your supervisor before this goes any further. This creates a record of your request and introduces a second officer into the interaction, one who may have different discretion. Step 5. Document everything. Remember the officer's name and badge number. Remember the patrol car number. Write down the time, location, and exact words used as soon as you are safely able to do so. When a supervisor arrives, address them respectfully and specifically. Say, thank you for coming. I want to cooperate fully with lawful commands. My question is specific. Am I legally required to physically surrender my driver's license to the officer, or is display of my license sufficient to satisfy my legal obligation under state vehicle code? I've displayed my license. I am not refusing to identify myself. I am asking what the law specifically requires. This is not a gotcha question. It is a legitimate legal inquiry. In many cases, a supervisor will de-escalate precisely because the question is legitimate and because the officer's demand may not be strictly supported by the specific language of the statute. Here is the single most important thing this channel can tell you. Look up your specific state's vehicle code before you need it. 26 states have some form of stop and identify statute, but the requirements vary enormously. In Nevada, you need only state your name. In Indiana, you may need to provide your driver's license if you have it in your possession. In California, you must produce your license, but California has no general stop and identify law for pedestrians. The ACLU has published a state-by-state breakdown of stop and identify statutes on their website. Cornell Law School's Legal Information Institute publishes statutes for every state. These are free resources. Use them. Screenshot your state's relevant vehicle code and keep it accessible. Let's bring this home. Know your state's specific laws on what identification you are required to provide and in what form. Display, don't surrender, when possible. Hold your license clearly visible rather than passing it through the window. Use the scripts. Polite, specific, non-confrontational language protects you without escalating the encounter. Record the encounter. You have a First Amendment right to record police performing their duties in public. If threatened with arrest, comply physically, but verbally state clearly, I am complying under protest. I do not consent. Your rights are vindicated in court, not on the roadside. Request a supervisor if the situation escalates, and use the specific language, am I legally required to physically surrender my license, or is display sufficient? And document everything immediately after the stop. Officer's name, badge number, patrol car, exact words, time, location. The law gives law enforcement enormous authority during a traffic stop. But authority has limits, and the difference between seeing your identification and seizing your identification is not just a semantic game. It is a legally meaningful distinction that affects your data, your privacy, and your rights. The officers who demand your card are not always wrong to do so, but now you know enough to ask the right questions, calmly, legally, and without fear. If this video helped you understand your rights, subscribe and hit that notification bell. We cover Fourth Amendment law, traffic stop rights, and the legal nuances of law enforcement encounters every week. Hit the thumbs up if this was valuable, and drop in the comments, did you know this distinction existed before today? I'll see you in the next one.